That's where we're getting robbed of our water. We have certain entitlements before anybody gets anything else.
I think that is total speculation on plaintiffs' part and breaks down their standing theory. Plaintiffs have no substantive legal entitlement to the particular amounts of water supply.
It's just shocking to me that somebody hasn't put signature to paper to finalize this thing. Can you explain what has happened?
We have very strong arguments. The law is clear. It limits protections of the savings clause to implementation of the comprehensive Everglades restoration plan. And that's important. Right here in this case, U.S. Sugar in its brief is absolutely explicit that this reservoir would only give it back half of what they think it's owed. They're owed. So that means they think that a almost $4 billion publicly funded project needs to be fully devoted to returning to them water lost as a result of protecting people from the catastrophic failure of the Herbert River Dike. And before you do any Everglades restoration, you would actually have to build another $4 billion reservoir to give them back the water they're owed. That cannot be what the comprehensive Everglades restoration plan and Congress's work to implement that means. So, one, we've got a really strong plain meaning argument. Two, it doesn't make any sense at all in terms of what this law was meant to do. From those two perspectives, I feel like the core and the environmental arguments are incredibly strong.
And so after today, what are the two options of what happens? Either if we win or lose, like what is next steps?
It could go a couple of different ways. The reservoir could continue being built and we could argue about operations, or they could yank approval for the reservoir, and I'm not sure what would happen then.
So, knowing that information, what do you think the gravity of this situation is and the overall Everglades restoration fight?
I mean, having storage in the central flowway of the Everglades is foundational. You don't have Everglades restoration without storage in the central flowway of the Everglades. And this is this is that project. So this is a linchpin to Everglades restoration. We've made incredible progress in the last, especially like 5 or 6 years with all the project implementation that's been happening. This would unwind a lot of that progress at best, if not, eviscerated entirely. So we are at the Federal Appellate Court for the 11th Judicial Circuit. The Federal Appellate Court hears appeals of lower court, district court decisions. So where we are in our process is the sugar industry filed a case back several years ago. We have already had arguments and briefing in a lower court in West Palm Beach, Florida. We won at that level. The sugar industry then appealed that lower court decision, and they come here to the 11th Circuit, where a panel of 3 judges will hear oral argument today. Each side gets 15 minutes. The federal government will get 15 minutes, and all of the sugar industry will get 15 minutes to argue, and the judges can ask whatever questions they have. After that's done, they take it under advisement, and we will get an opinion within a few months to several months.
We would say that's not enough. That's not what the statute says. And it's not what the regs say. They say you have to give us what we had in 2000 before you can continue to implement the plan. When we talk about lake levels, we were entitled to water rights to draw from the lake under a schedule that had a maximum elevation of 18.53. LOR's 2008 lowered that level to 17.25. And I think it's common ground between the parties that results in about a 500,000 acre feet of water loss for purposes of the baseline. That's where we're getting robbed of our water. We have certain entitlements before anybody gets anything else. we don't have a problem with the reservoir. We really don't even have a problem with the STA. What we have a problem with is that going into effect without our savings clause rights being respected. And the most obvious way to respect our savings clause rights is to find additional water, use the right baseline, find additional water to make up for the 160,000 that we're going to lose, plus whatever they think we're losing by shifting the baseline. And then we're all hunky-dory with the project. It's just that we're not hunky-dory with the project if it proceeds in violation of the savings clause and makes permanent a deprivation of our rights.
I'd say the natural reading of that is that the savings clause is triggered only when there is, I'm quoting now from the statute, water to be lost as a result of the implementation of the plan. I see what you've done. Your answer to Judge Newsom, you tried to change implementation of the plan from the project being challenged to everything the Corps ever done about the plan.
Reading the savings clause, as we have, comports with that overall context while also ensuring that water users are not adversely affected. Plaintiff's interpretation, on the other hand, would place agricultural needs above ecosystem restoration. The exception would simply swallow the rule if there were a provision that required the Corps to first prioritize building an insurance policy for industry before providing ecosystem benefits. I think if plaintiffs are correct that the Corps must make up for any reductions in agricultural water supply before proceeding with the CERT project, then the Corps will need to find some way to add on their theory 500,000 acre-feet of water that plaintiffs claim was lost since 2000 before building the reservoir and treatment area. I don't know how plaintiffs theorize that they will get there, which I think is a standing problem, but even setting that aside, perhaps plaintiffs believe that the Corps could accomplish this by building a second $4 billion reservoir the size of Manhattan Island, but I think that's rather unlikely. That would require Congress to pass a new statute authorizing that plan. In that sense, plaintiff's theory
and to my mind, that's getting to the absurdity and possibility doctrine.
Right. Well, it's just not as simple as opening some levers and finding 500,000 acre-feet of lost water before proceeding with this plan. It's possible, and though plaintiffs haven't really developed this theory, that they believe the Corps could use its authority under the Flood Control Act, which is the statutory authority it has to set these regulation schedules, to change the regulation schedule to raise lake levels. The fundamental problem for them, both on standing and the merits, is that they have simply not hypothesized any path that provides them the relief that they desire, whether that's through the existing statute or otherwise.
It was great to be in the courtroom today. It was an exciting oral argument, and it went long. We had the three judges were it was an engaged bench. They asked a lot of questions. That is good for us. If you understand the law at issue here, the Corps is right in terms of how it has, what it's done in terms of protecting water. So it was engagement, asking a lot of questions. The one big moment and one big issue that came up was the U.S. Sugars Council talked a lot about how our water and how that the Corps needed to design this project so they could get our water back. They were saying that public water supply belongs to them. It's theirs.
That's where we're getting robbed of our water. As I said, here, they took 50,000 acre-feet of our water, and the idea that they get to take 500,000 acres of our water. And just one last point, LOSIM does not moot this controversy in any way, shape, or form. It just makes permanent the stealing of our water.
So when they're saying you owe us our water back, and we're saying it's public's water, are we talking about Lake Okeechobee in this scenario?
In this instance, we are, because what the Sugar is saying is that when the Lake Okeechobee regulation schedule went in place in 2008, and water levels were lowered in Lake Okeechobee to protect the dike, to protect the community from a catastrophic dike failure, and to allow for dike repairs, that water was lost. That was our water. That was Sugar's water, and now they need to get that water back. So their argument is potentially broader, but in this case, the water that they lost, their water that was lost, was the water that was lost as a result of the Lake Okeechobee regulation schedule changes in 2008.
But again, when they're basically claiming Lake Okeechobee public water to be their own. Isn't that wrong and false? Like, how are they able to say that?
Yes, it is not their water. What they are saying is that the Comprehensive Everglades Restoration Plan passed in 2000 to protect the Everglades, and that what it actually did was guarantee their water supply forever against any action by the Corps. So sometimes they say it's not, if there's something, a natural disaster, we are not indemnified against that. But if the Corps tries to do something to prevent or address that natural disaster, then it's Corps action, and then they need to get their water back.
Interesting. I guess just overall sentiments. Are we feeling confident? How are we feeling after we just stepped out?
I'm gonna let Kurt.
I think that I'm not never predict an oral argument, but those were engaged judges. They'd spent some time with the briefs beforehand. They were asking pointed questions. I feel good when I have judges on a panel who've engaged with our materials and who are asking pointed questions.